In this consultation, we take a detailed look of the deprivation of liberty safeguards. We ask how we can achieve better, more appropriate outcomes for people with care and support needs, and at the same time reduce unnecessary bureaucratic burdens on local councils and the NHS. We also ask what safeguards we need for people receiving care and treatment at home and in other family and domestic settings. The Mental Capacity Act aims to protect people who lack mental capacity but need to be deprived of their liberty so that they can be given care and treatment in a hospital or care home. The deprivation of liberty safeguards are intended to provide a process for ensuring that people in these circumstances are deprived of their liberty only if it's in their best interests. But the safeguards provided aren't meaningful for these people and their families, and sometimes fail to protect their rights, and local councils and the NHS are struggling to meet their obligations under the current legislation. And people who live in other settings, such as supported living, are being left unprotected at the moment. We believe that the deprivation of liberty safeguards are deeply flawed. We're proposing that they be replaced with a new system of protective care, with safeguards extended to people who live in supported living environments or at home, as well as a more streamlined scheme for hospital settings and palliative care. We suggest that best interests assessors who carry out capacity and best interests assessments should have a wider role in the making and review of care plans, and we ask whether they should be given professional status and regulated in the same way as other care professions. We suggest that anyone subject to protective care should be provided with an advocate to represent their views and wishes, and appeals should no longer be heard centrally by the Court of Protection, but by specialist tribunals which would include medical and mental health practitioners, and potentially service users themselves. The deprivation of liberty safeguards have been called not fit for purpose. The current system is technical and cumbersome, and since a recent Supreme Court judgment, it has placed increasing burdens on local authorities and health and social care practitioners. Protective care is not about deprivation of liberty. It is about providing care. The reforms we are provisionally proposing would sweep away the current system and establish a new purpose for protective care, to provide better care and appropriate outcomes for disabled and older people and their families. We look forward to hearing your views. Our consultation is open until the 2nd of November 2015. Please see our website for full details.